Hi, everyone. Welcome to our fifth lecture. This week in criminal law, we're talking about defenses. So, yeah, without further ado, let's just kind of dive in it. So, when we're talking about criminal defenses, these are the kind of big things we're going to be talking about. We're going to be talking about what denial or a failure of proof means, what affirmative defense is, the difference between imperfect and perfect defenses, the whether or not the grounds are factual or legal, and the kind of outcome of either, or not necessarily outcome, but the explanation for some defenses might be justification or excuse. So we're going to talk about all these things. These are the broad strokes, big pieces. So we are going to talk about those a little bit more specifically as we go on. Real quick, before we dive any further, I do want to mention briefly, we're going to be talking about in different parts. We're going to use the term common law and statutory. And so that's important to note what the difference is. So statutory, remember, is the laws that were created by legislatures. These are the laws that we understand the majority of. They're the ones that went through the process of being created by a member of Congress or the House of Representatives. It went through a vote, it got passed, and it got approved. So that's statutory law. And then there's common law. And common law is what's essentially created by courts. It is the idea of precedent. Common law is basically just what's generally believed. It's not necessarily cold, hard law like statutory is, but it's still important to note that. So, technically speaking, if we were to break down criminal defenses, there are two types of defenses. There's the defense that's a denial, and there's an affirmative defense. If you remember in that not first slide, but the second slide, when we were talking about affirmative defense, we also said denial was called a failure of proof defense. And quite literally, the point of a denial defense is to deny a criminal element exists. And specifically, the way that this is typically done is to wait for the prosecution to fail to meet the burden of proof. And I believe we've talked about it before, but the burden of proof, which is often put on the prosecution, is the amount of evidence and the amount of hard, factual, relevant information that would prove to a reasonable, everyday person that the belief or the outcome is exactly as being suggested. And so when we're talking about a criminal defense, since the burden of proof is on the prosecution, as a defendant, you don't have to bring anything to court. That's a denial defense, where you just wait for the prosecution to fail to meet the burden of proof. You do not have to provide any other evidence. You just simply have to essentially either disprove or wait for them to fail. That's why it's a failure of proof. It's also why it's just called a denial. You deny that the element exists. Full stop. And so that's pretty much one of the big two ways that we have criminal legal defenses. The other one is the one that most people tend to be more familiar with, even if you're not familiar with the direct terminology, but this is the one that most people understand, and that's affirmative defense. And an affirmative defense, quite literally, is where a defendant raises a new issue that must be proven to a certain evidentiary standard. So, affirmative defenses, where a denial you just have to wait for the prosecution to fail. Affirmative is you are bringing forward something. This is where now you might have to provide some kind of evidence. This is where we were talking about it a little bit before, that if denial doesn't have evidence, affirmative tends to be. So what is also important here that I want to emphasize is that the first one doesn't need evidence. Well, I just said that. First one doesn't need evidence, second one does. Sorry. Distracted by my own notes. So it's important that these are the two basic categories of the types of defenses you'll see. Now, of course, we're going to talk about some other niche type of defenses, but they fall under that typically affirmative, and we'll get to that when we get there. So regardless of the type of offense, there are two outcomes. Pretty straightforward. The two outcomes are an imperfect and a perfect defense. Imperfect defenses are where the defense results in a reducing of the severity of the offense. In other words, you're still found guilty, but we've now made the argument that you shouldn't be as punished for it. A perfect defense will always result in acquittal. An acquittal is the fancy legal term for being found not guilty. Full stop. So that's why we said there's only two outcomes for a defense. It's a perfect defense or an imperfect defense. Perfect defense, you're free. You're completely found not guilty. Imperfect defense, you are still found guilty, but there was some other fact that played into it overall that reduced the either severity of the crime, it reduced the sentence, it even lowered the sentencing from a felony to a misdemeanor, whatever it might be. Those are imperfect defenses. So, when we talk about the grounds for defense, there's a difference between factual and legal. And they are quite literally issues of fact and issues of law. So when we're talking about factual issues, we're talking about actual evidence, real hard proven facts and information that are the things being addressed. I'm trying to be very specific in the way I'm talking about this. So when we talk about an alibi, where you have some kind of concrete example of this is where I was at this given place and time, and these people can confirm whether or not I was there, those are factual pieces that can be proven. That's why I say the grounds for defense either being on factual or legal. Fact means that it's related to the facts itself. Legal defense is talking about issues of law. Things that the law wasn't written the right way, or the way it was enforced wasn't proper, or had some issues. That's what issues of law are. And so specifically, I mentioned alibis for factual defense. For legal defense, the statute of limitations is relevant here. So if you're being, in a very weird hypothetical situation, if you are being charged with a crime and it is outside the statute of limitations, that would be a legal defense to make, is that you were being charged outside of what the statute of limitations is considered. And so therefore that could throw out the case. That's what we mean when we say an issue of law. Something with the way the law is written, interpreted, or enacted is the problem. So you're going to address that as part of your defense. Factual is just something about the case itself is wrong, not with the process, if that makes any sense. And then when we get down to any kind of affirmative defense, like I said, we're not denying and waiting for failure, we're actually adding something. The reason that an affirmative defense works comes down to whether we view it as a justification or an excuse. And I know it seems weird and counterproductive, especially with English, because you're like, well, justification and excuse are pretty much the same thing. But they're not. And this is something that I've talked about in this class before, and it's very important to remember. The way our laws are written, the way our system works, and the way we've chosen words is very, very specifically. We have very particular rules, very particular terms to ensure that if we're going to charge someone, if we're going to take away someone's freedom, that we are doing it in the most appropriate way. And I'm putting air quotes on that, but it's important to note that while justification and excuse might sound like the same thing, legally speaking, they are two very different things. And so you should be able to see that simply by my first thing. Justification, the focus is on the offense itself, whereas an excuse is focusing on the defendant. So while the terms might be very similar and they have similar outcomes, their focus or the way that we prove that defense is different. So justification, if the focus is on the offense, the goal is to say that the action should be considered legal, not illegal. Whatever the action that is being charged here, there was something that makes it or should make it legal. That's justification. Excuse is now focusing on the defendant, the person who committed the action, where they are not as responsible for their action, whether that be some outside circumstance, something else is the reason for the action. Again, justification, the action itself is the problem. Excuse, the person is related to it. That's our focus. Okay? So that covers our big, broad areas of defenses. So now let's actually get into certain defenses. And this is the one that people absolutely always like to talk about, especially when we start talking about defense, because it has a long history and it's complicated. So self-defense. So when we're talking about what kind of defense we're focusing on, self-defense will always be looking at justification. It is trying to say that the action should be legal. It's not an excuse looking at the defendant. It's looking at reasons to make it legally fair. And the other thing related to self-defense claims is that they're often related to statutory law. We're talking not about common law. We're not talking about basic understandings. We're talking about an issue of written law. And the whole reason why we even say this is that it involves the, quote, use of force. So, what the heck does use of force mean? In a traditional classroom, we'd probably spend about 5 minutes debating what use of force means. For our purposes, what is important for you to know, for all of you to know, is that the term use of force is problematic. The term itself is left partially vague so that it can apply to different circumstances. But the general idea is in that part underneath the green box here. So a successful self-defense claim must prove, and it must prove these four things. Number one, the defendant was confronted with an unprovoked attack. So you can't, if you are the individual who are making a self-defense claim, you cannot be the person who started the attack. You cannot be the person to egg on an attacker. You had to have been confronted unprovoked. Number two, the threat of injury or death was imminent. Imminent means it was going to happen very soon. Not, oh, they threatened to hurt me in 8 years from now. That's not imminent threat. Imminent threat is it's happening now. This third one, this is the one where use of force has gotten complicated. The degree of force was objectively reasonable. And there's the other big term for us today that's going to be complicated, is objectively reasonable. The concept here is objectively, meaning that without any personal feelings, biases, or emotions, everyone can look at it and see the same standard with objectivity, where they're not personally connected to it, that a reasonable person would also find it to be fair. So the degree of force was objectively reasonable. If some other random person was in the same exact situation, would they have come to the same conclusion that that type of force was fair and equal? And I know some people are going to be like, but that's, how can you be objective about the use of force? Exactly. This is why it's complicated and why we said this is the one of the issues of self-defense. And then the fourth component that must be proven for a successful self-defense is that there was an objectively reasonable fear of injury or death unless self-defense was used. And this is just as important as the other three combined. Because if all three of the first ones are there, that's pretty straightforward. But, and I'm going to emphasize this, this is not an every state thing. This is not a federal thing. This is where the problems get complicated. Some jurisdictions are more strict about self-defense than others, and some are way more loose. There's a reason that stand your ground laws are a whole complicated matter. These fall under self-defense. But if there is a reasonable fear that injury or death is going to happen unless the self-defense is used, then we're okay. But if there is not a reasonable fear, if it's just he said threatening words to me and I didn't take him serious, so I pulled out a gun and shot him, that would be unnecessary because the fear of injury or death was not severe enough. I would also say that the threat of injury was not imminent. The defendant may have been attacked unprovoked, but was the degree of force objectively reasonable? Is shooting someone for saying offensive words reasonable? Probably not. So, self-defense, yeah. So, this is another thing that I specifically want to talk about, is that there are extensions to self-defense. We understand self-defense pretty straightforward. It's not a complicated type of defense. But when we talk about the extensions, that's where sometimes people get a little bit confused. So despite not being the defense of oneself, these four other types are understood underneath the self-defense concept. So they're not called self-defense, but when we look at the ways to prove it, they follow the same rules as self-defense. They're just modified to instead be about yourself. They're related to something else. So defense of others. The idea is that if you see somebody being attacked and you come in and, defend them because they were not able to defend themselves, you still have to prove, number one, the person who is being attacked, were they unprovoked attacked or were they the ones that started it? Which, again, gets complicated. Number two, was the threat of injury or death imminent and going to happen right there if you had not intervened? Number three, the force you used, was it objectively reasonable? And then finally, if you had not intervened, would it have resulted in that person being injured or killed? If you can still prove those things, then you could make a successful defense of others. The same can be applied to defensive property and defensive habitation. So, defensive property and habitation are two very different things because property refers to things that you own. It could be land, it could be objects. Defensive habitation is defense of your home, where you physically live. So, both of them fall under the same kind of basic standard of defense of. However, I do want to mention one thing in particular with the defensive habitation. You are legally allowed to protect your personal property. You're allowed to protect your home. However, while you are allowed to defend your home, you cannot booby trap your house like in Home Alone. That is not considered a successful defense for habitation if they consider it because it is not a objectively reasonable amount of force used, so it's not considered part of defensive habitation. There's been cases about it. It's the only reason I bring it up because people always ask about it. You cannot booby trap your house. That's just not how that works. All right. And then I did pass over ejection of a trespasser. And it's kind of a weird one. So, technically speaking, if somebody is illegally trespassing, or just trespassing in general, because that means you're illegally on a place that you're not supposed to be. But if somebody is illegally on property that is not theirs, the owner of the property is allowed to remove them from their property. And the standards for it are pretty straightforward. Like, if they do not have a legal right to be there, they can be ushered off. However, deadly force is not allowed to be used in the ejection of a trespasser unless imminent deadly force was being threatened by said trespasser. So, and it's why I brought up stand your ground laws earlier. In some places, with the ejection of a trespasser in their particular writing and statutes, if somebody is on your property, you cannot force them out by shooting at them. In stand your ground law states where there's more leniency with it, that's a different conversation. But the standard is you're not allowed to do it unless there is a threat of imminent deadly force by said trespasser to you, the owner of the property. All right, moving on. We get to talk about the necessity defense. And this is also known as the choice of evils defense. Basically, the criminal act was necessary to avoid a greater harm. That is what we're talking about when we say a necessity defense. Because the idea here is that generally there are three elements to meet to explain how a necessity defense could be successful. And number one is that more than one harm would occur under the circumstances. Two, harms must be ranked where one must be more severe. And three, there is an objectively reasonable belief that greater harm is imminent and a lesser harm is the only way to avoid the greater harm. And if you just listen to that and you just read that and you're like, I still don't understand what you mean, let me give you a scenario and hopefully that'll help explain. If you see a gunman, somebody with a weapon that is getting ready to shoot up a building full of innocent people, and you speed up in your car and you drive through a business which doesn't kill anybody but does cause some injuries, and it resulted in you hitting the gunman with your car, incapacitating them until authorities arrive to arrest them, you could make the argument that you were making a choice of evils defense or a necessity defense. Because if you had not hit the individual with the gun, they likely would have shot up and harmed and possibly killed more than one person. Number two, if we think about it, property crime is way less serious than murder. So there is that difference. And going back to the objectively reasonable belief, I think most people would agree that stopping a gunman is better than causing some minor injuries. It's better than, just ruining a business's activities for a couple days. We can see that there is a reasonable belief The other part of this, and that part of that third one, is would it be possible to believe that that gunman would have been stopped by somebody else if you had not driven through the business? If the answer is yes, somebody else would have stopped him, then you do not have the necessity defense. If you are the only thing because you're the only one that noticed, that's a different conversation. The necessity defense quite literally means that the crime that you committed was only to stop a greater crime from happening. Full stop. When we say crime, it could be just harm, but the idea is it's the lesser of two evils. What you chose to do, you admit is wrong, but you are saying, hey, while this might be wrong, it is in fact, though, to stop something worse. So where self-defense is pretty much justification, focusing on, that a law should or shouldn't be wrong, the necessity defense takes the opposite approach. This is an excuse. This is saying, look, I know what I did is wrong, but I did it for good reasons. So hopefully you're already starting to see how, depending on the type of defense, can really change a lot. So there's another type of defense called duress. And it's in the same vein as necessity. This is an attempt to excuse criminal behavior, and I want to emphasize that part. Again, this is not justification, this is excuse. So, for the most part, necessity defenses assume that the perpetrator of the initial greater harm is quote-unquote nature. Duress is by a person, and I'll explain what I mean very clearly by that. When we're talking about a necessity defense, the idea is that you yourself had no control over the harm. You chose to do the harm because you were acting as an act of God. You were acting as a response to an act of God. The idea is that the greater harm that's being addressed is not something you had direct control over, and your actions were justified. Duress is where the perpetrator of the greater harm is also the person that's directing you. So what I mean here is duress is essentially where somebody else is taking control of you. So something that is needed to be explained is consent. Consent is voluntary and knowingly. If we're coming back to our conversation about intent, it's a knowing intent. Consent is saying, yes, I know what I'm doing and I'm doing this. Duress is taking consent and turning it on its head, because duress is not consent. You said yes to the crime voluntarily, but you did so because you had to. So very specifically for duress, you must prove that, number one, there was an imminent harm of threat to your person had you not acted. So, going back to necessity. Necessity is if you didn't act, a greater harm would happen to someone else. Now, you did this act because there was imminent harm threatened to you. Number two, there was an objectively reasonable belief that the only way out of the harm threat was the crime. So again, we're still following through with the only way out of this is to commit the crime. And very specifically, this is a very big piece. The crime response, the way to get out of that harm threat, cannot be homicide. That cannot be duress. It can be a whole nother other thing, but it cannot be duress if it's homicide. The idea here is that making a defense claim of you were under duress means that you were under a serious threat of potential harm from somebody else, and that is why you had to commit a crime, because that was the only way you could get out of that imminent harm. When we're talking about protecting oneself from deadly force, that is just self-defense. Duress is saying that you did these actions because you were under an emotional situation where you were essentially forced into that position. Self-defense is you made that choice consciously. This is why I said consent is important here. You don't necessarily consent when you're under duress. You are only marginally consenting because of the circumstances. Self-defense, you're doing it. All right. So, insanity. Let's just rip the Band-Aid off and address this first page real quickly. So, the insanity defense. Number 1, 4 states don't allow the insanity defense: Montana, Utah, Kansas, and Idaho. Why those 4 states? Honest to God, I couldn't tell you. But they're the 4 states in the United States that might have changed in the last couple years, but as of, I want to say, 3 years ago, maybe 2 years ago, these were still the only 4 states in the United States that do not allow the insanity defense as a legal defense in court. Okay? That's a fun fact. That's not something that's ever going to show up on an exam. So, here's what is important about the insanity defense. It is rarely used because it is difficult to prove. Let me say that again. It is rarely used because it is difficult to prove. Hollywood has done a great job of emphasizing and highlighting the insanity defense, but it does a lot of wrong because it really does damage the view that people have on the insanity defense. It is a very difficult thing to prove in a court of law, and that is the big reason why it's not often used. So there are 2 factors necessary to prove for a successful insanity defense. We're going to talk about it in more detail, but you need to have a lack of control, and you need to not be able to form intent. Those are 2 very difficult things to prove. That you're unable to control yourself and you cannot form the mental state of intent, that's hard to prove. So, the other thing that Hollywood has not done well with, that has misinformed so many people, is professional treatment is the only successful outcome here. People who successfully get an insanity defense applied, they don't spend, 6 weeks in a mental facility and go home. That's not how that works. These are long-term, intense oversight and mental health monitoring. There is no get out of jail free card. This is why I said Hollywood has done a really good job at misinforming people. It's because they make it seem like the insanity defense is I'll get out of jail in no time. Yeah, you may not go to jail if you get a successful insanity defense, but it's not a get out of jail free. It's a whole nother mess. So, we have developed over the years different tests to prove insanity. So there's 3 tests. There's a 4th test on here, and I'm just going to talk about it first, and that's the last one on the page. It's the Durham rule. It's essentially the product test, and it's exclusive to New Hampshire. Why? I don't know, because New Hampshire has to be themselves, but their whole concept for testing of insanity is proximate causation. They're looking for how close can we relate one action to the mental state. So really what they're looking at is that if you have a mental defect, that could be the cause for crime. And as you can see, that tends to be pretty light on its explanation. And it is more complicated than that, but it is the easiest of the 4 tests to prove, but it's also the weirder of the 4, and so that's why it's not commonly accepted. We use the other 3 way more commonly. So the first one is our oldest one, the M'Naughton test. It comes from England, 1843. That's not necessarily super important for you to know. Again, it's just kind of a fun fact. But we know this as the right-wrong test. And I want to emphasize, I know it seems you're like the right-wrong. Yeah, you're testing whether you understand the difference between right and wrong. That may sound really easy, but it's a very rigid test. There is no nuance. It is right and wrong. Are you able to identify the difference? So, on top of that, what this test aims to prove with its outcome in relation also to having a mental disease or defect. Okay? So, this is why I said it's hard to prove. You have to have a history of mental health issues. Whether that be you've sought professional help for a while or you were institutionalized or any number of things. If you have that first, now you have an easier time of getting to successfully claim insanity. But taking this test and passing it, well, rather failing the test, is showing that you have an inability to know the difference between what is morally right and wrong and what is legally right and wrong. Again, it's not just do you understand the difference between right and wrong, it gets very specific. So while the M'Naughton test is the oldest test that we still use, it's the good one. It's the one that we use because it's hard to prove. So unfortunately, because it was so hard to prove off of that test alone, we started developing other tests. And so the irresistible impulse test was kind of a response to the M'Naughton test being so popular for so long. It is more flexible than the M'Naughton test, but it's also used as a supplement. So typically, if you're going to make an insanity claim of defense, you're going to have to pass, or rather fail, the M'Naughton test and the irresistible impulse test. Both of those combined tend to be. And so, irresistible impulse test, you still have to have a mental health issue required part of your diagnosis. But now, the irresistible impulse test is looking at your ability for self-control. So we're looking at the awareness of your actions and your will, the ability to control yourself. This is where sometimes we talk about extreme cases of obsessive-compulsive disorder can cause people to, have obsessive compulsions. If you've ever known somebody that, they have to count the number of steps that they take with both their left foot and their right foot, and they always have to be even or equal, or that's a serious level of obsessive-compulsive disorder. But they lack the ability to control themselves. If they do not do their compulsion, they have to act it out. They have to finish it. And this is where we say that irresistible impulse test is used, because we understand that sometimes knowing right from wrong is a great sign of whether somebody is fit or not, but seeing if they have an irresistible impulse because of some kind of other mental disorder, that's a whole nother conversation that needs to be had. And that's why we've supplemented that test. So the Model Penal Code, we've talked about before, put forward the substantial capacity test. It is the most flexible of these three. It's rarely used, but it is something that exists and we occasionally use. Much like the others, it requires a mental disorder, mental disease, and a lack of substantial capacity to appreciate the wrongness of one's actions. In other words, you're taking the awareness of action from the irresistible impulse test, and taking the right and wrong of the Monotone test and saying, do you understand what you've done? Do you see, can you appreciate the wrong that you've done? And this gets into a weirder conversation about psychology and how people view that, people who are proud of their crime, well, clearly they understand the wrongfulness of their action, and so they appreciate it, and that's why they can't get the success of an insanity defense. But somebody who cannot comprehend or understand it, that's a different conversation. So within insanity, there's a couple other things that we need to talk about. And the first is that the mental competency to stand trial. This is a just pretty straightforward, legitimate thing where if somebody is deemed mentally unwell, unable to stand trial, they're not going to put somebody on trial that cannot actually go through the trial. And this happens not just with mental disorders, this also has to do with age. Super young people and super old people, we're talking, young like 8, 7, 6 years old, and we're talking extremely advanced age, especially if there is something like dementia or whatnot. They can't technically be tried because they're mentally unable to unable to stand trial. So typically speaking, if an individual is unable to stand trial, we delay their trial until they're well enough. In cases of advanced age and dementia and things like that, there are alternatives that we go through, but it's important to note that typically, if somebody is not able to stand trial, we wait until they have, I don't want to say be cured enough, but until they're well enough to stand trial. So it should be noted that an insanity defense is a excuse. If we're looking at our justification versus excuse, it is looking for an excuse. But if you have a failed insanity defense, you could get a guilty but mentally ill response conclusion. And that's just a failed insanity plea is resulting in guilty but mentally ill. The idea is that, yeah, you're found guilty for your crime. However, because there was a serious mental health issue related to it, appropriate help, and I put that in air quotes, is tried to be mandated by a court. Meaning, if you failed it because you weren't able to complete the tests, but there definitely shows a history of problems, they will likely, instead of just sending you to prison, will put you in some kind of system where you have access to the help so that you can get, hopefully, better. Now, temporary insanity. Perhaps one of my favorites. I even give you an example. 1994, Lorena Bobbitt. I'm going to talk about her case in particular because sometimes there is this subsection of insanity called temporary insanity. And it's where during the trial, before and after, a person can be completely mentally fine. But in extreme circumstances, especially around the time the crime happened, a person can be considered temporarily insane. If they had gone through the process at that time, it could, in fact, lead to somebody qualifying under insanity. But after everything had passed, and then in the courtroom, they seem to be totally fine now, that's a fair argument to say that at the time they were temporarily insane. Now, if you do not know who Lorena Bobbitt is, Lorena Bobbitt was a woman who had a long history of abuse, who was forced to abort at least one of her children, and was sexually assaulted. And in particular, on the night of her crime, when she was being assaulted, she cut off her perpetrator's penis. And it being 1994, a different time in the world, especially for women, and especially related to sex crimes and intimate partners and things like that, she was charged with serious assault with a deadly weapon. She cut it off, and her legal team made the argument that she had a long history of being abused by this person and others, and she had finally had enough of it. And on the night of that particular abuse, she reacted and cut off his penis. And yeah, the court said, yeah, she was, based off of all of the extreme circumstances around it, yeah, at the time. Is it right ever to cut off somebody's penis? No. But I can see why she went that way, especially given everything else. So they granted temporary insanity. And yeah. She wasn't found fully guilty because of it. So keep that in mind. All right. So some other legal defenses that we should talk about. We don't need to go into as deep of detail as the other ones, but they're still important to note, is things like infancy, which quite literally means you're too young to know better or be charged. Obviously, we use this when we refer to juveniles who've committed serious crimes, especially if they lack the ability to understand the severity of their actions. Think, the toddler who shoots somebody. Do they necessarily know the total extent of what shooting somebody means? Probably not. Family could make a legal defense of infancy that they're not old enough to understand. That's pretty straightforward. Intoxication is an interesting legal defense because, plain and simple, it's a disturbance in one's mental or physical capabilities that led to an action. When we consider intoxication, we typically are talking about alcohol, but it can be drugs and other mind-altering substances and states of mind. What is important here is there's a difference between voluntary intoxication and involuntary intoxication. Voluntary intoxication is you choosing to go to the bar, buying a bunch of drinks, and getting behind the wheel of the car. Those are all voluntary choices. You chose to drink, you chose to go out, and you chose to drive. You could not make the argument that you were involuntarily intoxicated. You made those choices. However, if you went out and somebody drugged you, the actions you did while you were under that influence, you could make the argument you were involuntarily intoxicated. Somebody drugged you, you did not consent, and therefore your actions are not fully your own. Consent matters here, people. Intoxication, I'll tell you this right now, involuntary intoxication as a defense works a lot more frequently than voluntary intoxication. Because it's a lot harder to make the argument that, yep, I chose to do this. I chose to change my state of mind, but I still shouldn't be in trouble for the actions I did. It's a lot harder to make that argument. We also have the legal defense of mistake, which comes back to one of the things we were talking about way back in the beginning of this, which is the mistake of law and mistake of fact. A mistake of law is where the belief is that the act itself is legal. A mistake of fact is that the facts as the defendant believes them to be negates the requisite intent. In other words, the way or the facts that the individual who committed the crime believes them to have been at the time would make it so that the illegal action was not actually illegal. They lacked the intent. They did not intend to commit that crime or commit that action. It was simply misunderstanding of the facts of the case. So, for instance, a good mistake of fact example would be being told by your friend, hey, I have a cabin out on Route 8. Here's the address. There's a key underneath the doormat. Let yourself in anytime. And you happen to go to the wrong cabin, and there's a key under the door, and you go in, and now you're trespassing. There's the legal ability to say it was a mistake of fact. You believed you were at the right cabin, all the things lined up. The fact that you were trespassing was unintentional. You believed you had consent from the owner. You just happened to be at the wrong place. That's a mistake of fact. A mistake of law is pretty much anyone trying to argue that if something is illegal, it shouldn't be illegal. Pretty straightforward. The last legal defense I want to talk about is entrapment. And this is the use of inappropriate persuasive tactics by government officials. Please note, I've made this big letters. Entrapment only counts if it is by a government official. I, as your teacher, cannot entrap you. Not legally. Entrapment is the use of inappropriate persuasive tactics by government officials. This means police. This means FBI. This means ICE. This means your senators. This is everyone that's a government official. So, very specifically, the focus of entrapment is on the origins. Okay? What I mean is that if a crime is committed because a police officer coerced you, it's entrapment. The origins of the criminal activity, if it comes from a government agency or a government official, it's entrapment. If you were going to commit the crime anyways, it is not entrapment. So, you buy drugs off of an undercover cop is not entrapment. You were already planning on buying those illegal drugs. Now, a police officer telling you to go buy drugs only to be caught by a different police officer as part of a sting operation to catch drug addicts, that's entrapment. The origin matters. If you were going to commit the crime without any kind of coercion from somebody else, it's not entrapment. The moment that the coercion matters, the moment that that decision has been made for you by somebody else, now it's entrapment. Subjectively, the defendant has a predisposition towards crime. Objectively, the law enforcement behavior. That is exactly what I was talking about. For entrapment to work, to be a legal defense, you had to not have wanted to commit the crime in any way, shape, or form. The only reason you did it is because somebody of authority and power told you to do it. That's entrapment. Okay? And just like that, we're at the end. Thank you very much, ladies and gentlemen, for sitting through this. I know it probably wasn't easy, but it is what it is. So I want to thank you for listening, and good luck on your well, I mean, you've already completed your midterm, so apologies on that. Good luck. Good luck because I'll be grading them. But make sure you're doing case study response number 4 and 5, 5 and 6, whatever the numbers are. And I'll see you in the next video.